This is the plaintiff, Merritt Young. She says she rented a condo from the defendant, and the irresponsible woman hired an unlicensed plumber to do work on her bathroom, and he started a huge fire. 24 apartments were affected. The building had to be vacated, and the woman tried to get her to lie to the Homeowners Association and say the plumber was indeed licensed. She refused. She moved out after 10 years of living there, and now the defendant won't return the $1,800 she owes her. So she's suing. This is the defendant, Joanne. She says she rented her beautiful condo on the water to the plaintiff. And when she put it up for sale, the woman turned evil. That's right, she did everything in her power to obstruct the sale by not granting access to potential buyers. She lost out on a sale. The plaintiff wrecked the place before she left. And if anyone's owed money today, it's not the plaintiff. She's accused of a terrible tenancy. The defendant has filed a countersuit for $3,000, the money it cost her, losing out on a sale.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket, the plaintiff says an unlicensed plumber hired by the defendant started a fire and the plaintiff had to vacate the apartment. But the defendant says the plaintiff turned evil once she found out she was selling the condo, and that's what's really behind all this. It's the case of what a terrible tenant.
Thank you, Douglas.
Welcome, ma'am.
Okay, Ms. Young.
I am here seeking a security deposit from an apartment I rented from the defendant from 2010 to 2019.
Okay. And how much was the security deposit? $900?
Correct. Yes.
Okay. And because Connecticut law says that if you don't if you don't follow the law, you get to double it, then that would be $1,800, correct?
Correct. Yes.
That's why you're seeking double. Now, how long did you live there?
9 years.
It's a really nice place.
It is.
Where is this?
In Milford, Connecticut.
It's beautiful. Anyway, so I'm sure you enjoyed living there. And then at some point in July of 2019, she informs you that she's going to sell the condo and that you need to live somewhere else, correct?
Correct.
And how did you react to that information?
Well, first of all, the realtor that was working with me tried to find an investor, meaning someone would buy the condo and I would remain there. It would be an investment.
Yeah, you wanted to stay there. I don't blame you. I don't blame you. Ms. Joanne, let me ask you a question. She lived there for almost 10 years, and then everything was great until you told her you were selling. According to you, what went wrong once you told her you were selling?
At the beginning, she wanted to rent and buy later on. And then in September of, I believe it's 2018, before it went up for sale, that September, I asked her if she was, at this point, ready to buy. And she said to me, no, you know I can't. And I said then, because of my health and dialysis and transplant and everything else, I needed less responsibility. And then I did revisit with her in June of the following year, and I said to her, we are going to put it up for sale.
I have a question for you. Is she on a month-to-month tenancy, or was she in the middle of a lease?
Yes, it started to be month-to-month.
Right. If it's month-to-month, you don't have to give her any more than 30 days notice that you want to sell. There's no blood oath between you two where you have to, get her approval to sell. It's not your place. If you're on a month-to-month, Ms. Young, all you have is a right to live there 30 days. But when did you sell the condo? When did you have it sold?
In January of 2019.
Okay. All right. And so she moved out in anticipation of the sale. She did finally move out in January, right? So then why are you counterclaiming $3,000? Can you explain your counterclaim to me?
I had to meet with Prime Properties maybe over 100 times because of her harassment, her negligence, her dog peeing everywhere. And every time I had to go, I had to pay a fine because of what was happening. I have submitted.
Why didn't you submit the bill to her when she would do that?
I have letters that I sent to her.
Did she ever pay them?
No.
Did you ever pay any of your fines, Ms.
I was never
Young?
asked to pay.
Well,
I
that's
was
the part
never
I'm surprised
asked.
about. You had the most beautiful spot in the world and a landlord that doesn't demand anything of you. I don't understand why, if you're getting fined over her dog and her behavior, I don't understand why you're not submitting them to her the next month and saying you got to pay this.
But I did. I sent them to her. I have
And
copies
then you
of
tell her for non-payment of rent, you're getting evicted. Then that's non-payment if she doesn't pay them. You don't have to take it lying down.
You are so right.
Welcome back to the People's Court. The plaintiff says 24 apartments were affected by the defendant's negligence, and she is owed money big time. But the defendant says the woman is just trying to obstruct the sale of the apartment, and she can't wait till she's done with her once and for all. Let's go back into the courtroom.
Your Honor, I did want to finish why I was countersuing. I had a buyer, even like on the very first day that it went up for sale, and it was a neighbor's mother that wanted. She knew the layout, she knew everything. But because of Florine, she wouldn't let anyone in. You had an appointment. She found every single excuse as possible. 3 months went by, and the woman decided, because I don't need any of this frustration. And in the meantime,
Okay, but now I need you, even if you were able to prove that, it would make no difference to me, and I'm going to tell you why. You had a situation where it was a month-to-month tenancy. You absolutely, 100% had the right to file a termination of the tenancy. It's not even an eviction for non-payment. It's just, hey, we have other plans now, and you go to court, and first you send her a notice that says, you're terminated, you got 30 days to find another place to live. Because that's the only right she has. And your realtor, I know you had a realtor helping with that. I don't understand how the realtor didn't explain stuff like that to you. I mean, yes, court takes longer than we want it to. That is true. That is part of the reason why that even during this COVID pandemic, the People's Court is open for business. Because we know that you guys have stuff hanging over your heads and that you need resolution. People need resolution, okay? Now, let's talk about the damages to the place. That's what I would like to go over. What is this a picture of?
it needed a lot of cleaning.
Yeah, kind of gross. Damaged cabinets. Okay, there's a face missing down there.
Right.
So there was a glass sliding door that you had to replace, and that had to be replaced. Why?
Because Florine's chair, iron chair, hit the door, and
Okay.
it cracked.
Do you have a picture of the cracked sliding glass door?
I deleted it, believe it or not.
Why would you do that?
Stupidity.
Did you break the sliding glass door? Because I do see a bill for replacing it, and it says that it's broken. So did you break the sliding glass door, Ms. Young?
No, it was 30 years old.
Is that accurate, that the sliding glass door that was broken was a 30-year-old sliding glass door, Ms. Joanne?
It was the second one in the unit. Now, I don't know when the first one was installed, but I did it when I bought it. And that was...
All right, and the other thing that you're keeping security deposit for is plumbing bills that you got. Pretty big size repair is something about candies that were, apparently candies were making their way into the electrical heater in the bedroom, melted candies or cough drops. Ms. Young, melted candies or cough drops, you remember that? In the making their way into the heater?
No.
Okay. You know, it's kind of hard to try to figure out the value of either a 30-year door, a 10-year door, a 15-year door, but what time is it, Douglas?
Well, Your Honor, I'm feeling like it's a little rough justice coming.
It's rough justice time, isn't it? But, you know, look, from what I'm looking at, the damages here are way more than $900, and I am not going to find in your favor, Ms. Young. I find in Ms. Joanne's favor on this case. And Ms. Joanne asked for your counterclaim against Ms. Young for this speculative $3,000 because you could have had a buyer but didn't, that was all in your own hands. You could have evicted her. You didn't because you wanted to continue to have the place occupied and collect rent. So you don't win on that counterclaim. On that counterclaim, I rule in favor of Ms. Young. Good luck, folks.
Well, the plaintiff does not prevail in this case. Let's talk to her and see how she feels about it. Ms. Young, what do you think?
I feel as though a lot of the damages she's claiming covered a long span of time, not just the last year or two.
Bottom line is, are you okay now? Are you happy where you are now in your new apartment?
Oh, I'm happy where I am now, yes.
Okay, well, good for you. Sorry you lost the case. Ms. Joanne, let me ask you a quick question. You got some really good advice from the judge. You probably should have talked to a lawyer and you could have gotten her out a long time ago if you really wanted to, you know? She was on month to month.
Exactly. I could have and I should have, but that's my fault.
Yeah. Well, you learned a lesson. Well, listen, you won the case, so congratulations. Okay, these are fascinating cases about renting issues. Comes up often in court. Let's join Judge Millian and her husband, Judge John, for more of our after the verdict conversations.
Marilyn, you found for the defendant in this case, the landlord, and the relationship between these parties is what we call tenancy at will at common law, which means you're kind of there at the will of the landlord. We usually call it a month-to-month tenancy as well because it takes 30 days or so to get somebody out through the eviction process or to give them proper notice. So someone who is a tenant at will or a month-to-month tenant doesn't have a lot of leverage in this type of situation when it comes to whether they can buy the unit, things of that nature.
Here's the thing, there were fines, but even not counting those, the damages were enough, and she had been specific enough in her letter, which Connecticut law requires, that they amounted to more than $900 worth of damage. And even though the plaintiff was kind of savvy, she knew Connecticut law, so someone tipped her off that if she doesn't give specifics in a letter within X amount of time, that then you can double your request. But I don't think it got anywhere near that because there were enough, in those pictures that I saw, especially the $500 electrical one from Candy's melting in there,
But at the end of the day, the damages certainly outweighed the
They outweighed the amount of the security deposit.
Very well.
So Christine wants to know this. Hey, Harvey, if a jerk parks directly behind and across from my driveway on the street and I back into them, are they at all responsible for the damage of being parked improperly? That's a good question. And the answer is no, they are not responsible. If you are backing up, you have a duty to see what is behind you. And even if they're parked illegally, it's a stationary vehicle and you got to use your eyes and you got to use your mirror and you got to avoid the accident. And that'll do it for this case. The litigants for the next case are inside the courtroom.